Here we have an introduction to the criminal justice relationship between Canadian courts and Indigenous laws. This is coming from Don Coutieri, Judicial Reasoning Across Legal Orders, Lessons from Nunavut, from September 7th, 2020. Okay, so commentators have long noted the failure of Gladue, the case Gladue, to mitigate the mass incarceration of Indigenous peoples. Um, a later case, Ipili, not only clarified that sentencing judges must take into account Canada's history of colonialism in residential schools, but it also pushed further by emphasizing the need for judges to explore alternatives to incarceration due to the failure of the criminal justice system to respond to the needs of Indigenous peoples. Um, so 635 Gladue decisions were reviewed, and it was found that incarceration was imposed in 87.7% of those sentencing decisions. Um, Only 30 decisions applied restorative justice principles despite their explicit endorsement in Gladue. So, in the case of Gladue, restorative justice principles were endorsed. So, in order to achieve greater plurality, or basically harmony between Indigenous laws and the Canadian criminal justice system, this author is proposing we have two major points. One, ethical space with Indigenous laws, so by exploring apparent overlaps and conflicts with the Canadian law. And then two, a process of harmonization will flow after that, where laws coexist in mutual non-interference, and there's concurrent application reinforces both legal systems. So concurrent application will then reinforce both legal systems. One of the major issues we're dealing here is whether courts ought to engage with Indigenous laws, and if so, under what circumstances. This author breaks this down into four parts. So first, he's taking a look at the Nunavut context and analyzes Iterligak in light of Ipili. So IQ, which is an Inuit term, short for an Inuit term, is a holistic set of values and practices used within Inuit society that refers to how to be in the world. The Nunavut Court of Justice, Canada's only unified court system, pursues culturally appropriate court processes, sentencing alternatives, and community engagement through elder and youth panels and sentencing. So, reasoning arranges the sentencing objectives under Section 718 of the Criminal Code, specifically denunciation, deterrence, separation from society, and rehabilitation, to roughly accommodate the Inuit societal values, suggesting a degree of symmetry between the legal orders. And this aligns with the Supreme Court of Canada precedent that the sentencing judge must determine which objective or objectives merit the greatest weight given the particulars of the case. Despite this, Canadian sentencing law arguably remains fundamentally committed to deterrence and retribution as overriding objectives. Iterligak richly integrates Indigenous law perspectives in the charter analysis to reduce the impact of community separation. So these principles permeate the Gladue and Section 12 analysis to put Inuit societal values into the foreground. Okay, part 2 of this article investigates, with references to Iterligak, questions of whether Indigenous legal orders are commensurate with Canadian law and whether judges ought to engage with them. He starts with little guidance exists on how or even if courts should engage with Indigenous laws. Two separate inquiries follow. First, are Canadian and Indigenous laws cognizable to one another? Is there commensurability? Second, if they are, ought judges, particularly non-Indigenous judges, are they okay with engaging with Indigenous laws in their judgments? And that's normatively. So where symmetries arise, this author argues that Indigenous laws can and should apply concurrently at the same time. Where no symmetry exists, deference to indigenous practices is more appropriate, and only statutory or doctrinal reform will enable equitable conditions for concurrent application. Okay. Aboriginal title invariably preserves the legitimacy of Crown sovereignty. Aboriginal title is but a burden of collective ownership on the underlying radical title of the Crown. In stark and obvious contrast to this, many indigenous nations assert ultimate sovereignty over their own territory, either through such arguments that such territory was never ceded to the Crown, or where land surrender treaty was signed, through claims that the written text does not reflect the oral agreement between the parties. The author notes that the federal court has developed expertise in adjudicating First Nations governance disputes and offers mediation services that allow indigenous laws and principles to permeate dispute resolution. The federal court defers to indigenous decision-making processes as they are obviously in a better position than non-indigenous courts to understand indigenous legal traditions. Notably, while the federal court has not developed its own method of interpreting indigenous laws, it does adapt the judicial process itself to integrate indigenous laws in conflict resolution. For judges to fully grapple with and defer to substantive principles and processes of indigenous laws, they must be free to depart from the punitive ethos binding them under the criminal code. The only fair and just reconciliation is one which takes into account the Aboriginal perspective while at the same time taking into account the perspective of the common law. True reconciliation will equally place weight on each. That's from the Vanderpeet case. Part 3 of 4 discusses the limits of such analogical reasoning and uses IPAC to illustrate an ethical framework for internormative dialogue in which indigenous laws receive greater deference. Okay, judges must carefully contemplate whether judicial consequences nullify indigenous processes intended to flow from the principles that they recognize. Gladue and charter analysis may provide entry points for indigenous laws to inform judicial reasoning, but indigenous laws will not and should not be made to fit neatly within legal tests. IPAC exemplifies judicial reasoning across legal orders in a manner that upholds both traditions while respecting the incommensurability of certain concepts and giving them determinative weight in the result. Judicial reasoning, then, must tread carefully between referencing indigenous laws to emphasize mutual goals and controlling, and thereby perverting the meaning of these principles. His analysis relied on the conclusion that state actions are not entitled to the same level of deferences as Inuit justice processes. Again, from the IPAC case. Part 4 of this article synthesizes the lessons drawn from those inquiries and considers institutional and legislative reforms that ideally should accompany greater internormative judicial reasoning. The lessons from Interlingak and IPAC reveal a pattern of analytical groundwork that must occur at the outset of judicial analysis. The first step, establishing ethical space, dictates whether the next step, harmonization, results in principled synthesis or deference. Irreconcilable incommensurabilities, particularly in sentencing, require deference at the harmonization stage of the analysis. But where no alternatives exist, they ultimately require institutional and legislative reform. Advances made by the federal court show that institutional reform may emanate within courts, but legislative reform obviously exceeds the judicial role. Pluralism between indigenous laws and Canadian law deserves our attention because if done right, it facilitates parallel rather than oppressive justice systems. Thank you for watching my video. Please do me a big favor and hit that like button and subscribe to get more videos on law school and NCA exam prep.